Of the Supreme Court. Hear ye, hear ye, hear ye. This court from recess now sitting.
Thank you. Please be seated. We now turn to the last case on this morning's docket. That is case number 102071, State of Kansas v. Rex Reiss.
May it please the Court, my name is Matthew J. Edge. I'm here on behalf of Defendant Appellant Rex Reiss. With the Chief Justice's permission, I would like to reserve 3 minutes for rebuttal.
3 minutes is granted.
Thank you, Your Honor. So what we have here is a case of a unintentional detention, I suppose you should say. We have a 2-lane blacktop highway. The cars are closely spaced together so that the officers, in stopping the intended vehicle of his stop, also happens to ensnare my client as well. And the Court of Appeals has analogized this to cases where innocent passersby or occupants of a vehicle are detained. And I think that the question before the court is really whether this doctrine can be expanded beyond, say, the passengers of the vehicle or the occupants of a house that is the subject of a warrant to people in the vicinity. And I think this is a dramatic expansion of the doctrine that is cited in the Court of Appeals opinion. And specifically, I think that we can go further to say that, whenever we're talking about police detention, we always have to say that one of the doctrines of it is that the contours of that detention have to be narrowly tailored to the purposes that that justify the detention in the first place. And I think that even if we're going to allow a detention of people who are accidentally caught up in the dragnet, as it were, then there needs to be a kind of, I guess I would call it, a positive detention or reverse detention. Instead of detaining you in an area, a police officer also has the power to tell you to get out of an area. And I think that in this particular case, this would have been well suited to that kind of approach.
Didn't he say that was his intent, was to approach that vehicle and say, just get out, but it was your client's actions that caused pause in that?
Well, my client's actions were simply that he wanted to know why he was stopped. And rather than the police officer telling him, I didn't mean to stop you, get out of here, he then decided that he wanted to detain him and investigate further. And I think that in that case, it really takes...
Weren't there some initial observations made about his condition when your client got out of the car and said, why did you stop me? Didn't he observe some behavior that caused him to pause on whether he should leave or not?
I think that
or is that stretching?
Is that stretching? Yeah, that he was waved. And I mean, the officer never actually says that he's being violent or belligerent, but he says that he's very excited, he's very voluble, he's waving his hands. But I think notably, the officer never testifies that he feared for his safety or that he felt that Mr. Reiss's behavior would interfere with the purpose of the stop.
When did he see the gun, the shell outside of the vehicle? Was that right at that point in time, or when did he see that?
I'm sorry?
Shell casing.
The shell casing outside the driver's side of the car on the pavement. When did he see that?
I don't recall when he did, but I mean, I don't. I'm sorry.
It was later, I think.
Later. Okay.
Yeah, I think that was like after he tells him to get back into the vehicle, which is what we're saying is the unlawful detention. Okay. And then he approaches the vehicle later, and that's when he notices the things like the shell casing.
Your reading of the record is that there was no observation that he might be intoxicated or thought that he might be intoxicated until after he was already back in the
That's correct. After the officer approached the vehicle, that's when he observed the signs of intoxication. Now, prior to that, all he says is that that Mr. Reiss is coming towards him, and I think in the Court of Appeals we had a big argument over the semantics of whether this is rushing or charging or simply, approaching very quickly in a walking fashion, and then he's being loud. But I don't know that he was being particularly combative. He wasn't using insulting language or rude language or threatening language. He was simply, "Why am I being stopped?" And the officer said, "Get back in your car." And that was the extent of the interaction at that point. And it's later, after he approaches the vehicle, that he notices the teary eyes and the odor and et cetera, et cetera.
What should the officer have done here? I mean, just let the driver that he now believes to be intoxicated to go?
Well, I think that, first of all, the intoxicated, I don't think that he has reasonable suspicion to believe that he's intoxicated until after he approaches the vehicle.
I understand that, but after all of that occurs, what should have happened?
Well, I think at that point, then...
Say have somebody come pick you up.
Yeah, at that point, he does have, I think he can justify the detention at that point. But that's not when the inception of the detention was, and it has to be justified at that point. I think that he had two options at that point. He can either say go, or he can say, stay in your vehicle, but as long as he stays in his vehicle, then he's no longer a problem. The officer can carry out the purpose of the stop.
Something caused the officer to call for backup, is that right?
I believe so.
Do we know from the record what caused the officer to do that?
I don't believe that he stated on the record. It could well be that it's simply routine, particularly when he's stopped multiple vehicles.
So the record does not reflect why the officer did that?
I don't recall that there was any discussion. I think he says that he calls backup, but I don't recall that he gives a specific motive. But your recollection of the facts may be much fresher than mine, Your Honor. So,
thank you. Justice Lukert?
Well, I was just going to follow up on, didn't the officer specify he had concern about turning his back on the car and that he would have had to have done that to have continued with the traffic stop of the truck that didn't have its lights on? Isn't that contrary to your argument that once your client was back in his car, he was no threat?
Well, yes. I mean, once he's back in his car, he's out of the way. He's out of the picture. I mean, I suppose at that point you could bring in another officer to observe him to make sure he stays in the car, but it's another thing to go ahead and investigate those people. I mean, and I think this dovetails nicely with the cases that the Court of Appeals has cited to justify the extension of this doctrine. In Rattel, you have the occupants of the house who are detained in the execution of the search warrant. But in those instances, we're simply doing what we need to do to allow the officers to effect the search warrant. And granted, that involves holding them at gunpoint naked for a few minutes until they determined that the people that they were looking for were not there. But I don't think that justifies a further investigation of the occupants of the house to determine, who they are, what criminal activity they may be involved in, persons who are stopped in the passengers of a vehicle who are stopped. That doesn't automatically give the police the right to search their persons, except for perhaps a pat down for officer safety or something like that.
I'm unclear. As you think the detention began when the officer told Mr. Reiss, who's standing outside his truck, to get back into his car.
Right.
Is that
well,
right? Is that the first detention, or is there anything else that's? I'm trying to figure out when we've got the detention of your client.
I think that the answer is, it is a weird fact pattern. the clearest I could think of is that, you have to have the display of authority and the submission to that authority. So technically, it's not when the officer says, get back into the car. I was misspeaking. It's actually when Mr. Reiss gets back in the car. I don't know that really makes a distinction here. You have a display of authority when the officer turns on his lights, and Mr. Reiss submitted to that. And I guess
That's not a detention. I mean, when
right.
any number of times
right, because the officer,
I pull over to the side when there's
Right.
red lights and sirens so that they can go get the person they're interested in.
exactly.
Your problem is the guy's buddy's up ahead and they pull over together and he sticks with him and then gets out of the car. So
Correct.
Is there a detention anywhere in that part of the action?
I think there might be, but I don't know that part of it isn't problematic yet, because you have a display of authority when the officer turns on his lights, but it's not directed at my client.
Do we have anything from your client? One would presume he thought he was the object of being stopped, since he jumped out and went back towards and hollered, "Why are you stopping me?" But was there any other evidence to indicate that he thought he was being detained by the lights rather than just pulling over and allowing an emergency vehicle to go on?
Well, I mean, anything I'm sorry, I guess I don't get the gist of your question, Your Honor. Was there anything that Mr. Reiss believed that he may have been doing wrong at that point, or?
No, we're talking about his belief that he was being detained at the time he stopped his vehicle.
Other than that, he's saying, "Why have you stopped me?" I don't know that,
And when the officer approached the car, my understanding was the first thing the officer did was ask for license and registration.
I believe so, Your Honor, yes.
Was there any evidence that the officer had formed reasonable suspicion of an alcohol-related offense prior to asking for license and registration?
I don't believe so. I mean, the officer's stated belief was that, I think he said something to the effect of, whenever you have anybody behaving like that, it gives me pause, and that's something I want to check up on. But I don't think that he mentions
You can pretty
alcohol.
clearly say that when the officer took possession of the driver's license and the car registration, that we had a detention, can't we?
Yes, Your Honor.
Any further presentation, counsel?
I have nothing to add at this moment, Your Honor.
Any more questions of counsel? Thank you.
May it please the court, my name is Cheryl Pierce. I'm Assistant Butler County with attorney.
When do you think the detention first occurred?
I don't think the detention first occurred, Your Honor, until after the officer had in fact observed indicators of being under the influence.
And when was that?
That was after he approached the vehicle. After the defendant had gotten back into the vehicle, he approached the vehicle. He asked the defendant, "Why did you get out of the vehicle?" And the defendant indicated, "I do not know." And at that time, while in making that inquiry as to why it was that he got out of the vehicle, the officer in fact noticed the bloodshot eyes, the slurred speech, the inability to understand the defendant's, and then he began to develop the reasonable suspicion that in fact he was under the influence, and he did at that point ask for his license and his registration, and that's when the detention began.
So that getting of the license and the registration did not happen until after he began to suspect intoxication.
That's correct.
Okay.
While making the inquiry of the defendant as to why he got out of the vehicle, he made the observations of being under the influence and proceeded at that point.
When the officer was asking the question, at the point the officer said, "Get back in your car," was that defendant free to go?
He wasn't not free to go.
What would a reasonable person think?
Well, I think a reasonable person would think that he was being directed back into his car. But for the purposes of whether he was being detained or
He
not,
was being directed back into his
He was
car.
being
I'm asking,
directed-
would a reasonable person think he was being directed back into his car so that he could take off?
I don't think so.
Right, so
I think that when you look at
let's
all
assume he was detained then, at that point.
No, I disagree with the fact that the detention began at that point. Because I think when you look at all of the surrounding circumstances is what we look at, what was going on. What was going on was the officer was asking the individual to return to the car so that the officer could control the situation.
But the individual he asked to return to the car already believed that he was the person that had been stopped.
He didn't know that. How could he have known that? There were
It isn't
three
a question.
cars.
It isn't what he believed. It's what a reasonable person would believe.
I don't know that a reasonable person would have believed that he was the target of that stop when there was three other individuals that stopped at the same time.
Would a reasonable person have thought they could leave after the officer had ordered him back into his car?
Once the officer approached him, yeah, well, I guess no. I think I have to concede that, in fact, that when an officer tells you to get back in the car, that you have to get back in the car.
So the detention starts there. And then I maybe have misunderstood, but I thought that the record had been pretty clear that the officer said he did not see bloodshot eyes or slurry speech before he asked for the driver's license. So what did he?
I think it was.
What did he observe that?
I think that it was at the same time that he was talking to him at the defendant. I don't know that you could slice it that narrow. Because as I understand it, the officer was talking to him and asking him, why did you get out of the car? He says, I don't know. And he makes the observations of the defendant's condition at that time. And then asked for his license and registration. I don't believe that it was just immediately walked up to the car and asked the individual for his license and his registration.
So your entire basis is reasonable suspicion. It's not officer safety at that point?
Not at that point, no. It's the state's position that the district court analysis and the district court's finding was appropriate, that there wasn't a detention at the time that the officer ordered him back to the car for the purposes of suppression. The detention actually occurred later in that discussion, later after the officer observed the indices of being under the influence.
I guess I'm confused, counsel. I thought you conceded to us just a few minutes ago that the detention began when he was ordered to go back in the car because a reasonable person would think it was inappropriate to leave. Did I misunderstand you?
I don't know that I guess my answer to that is yes, he went back to the car as he was told to do, but for the purposes of a Fourth Amendment search and seizure, did that detention mean a detention that you can't leave? I mean, I guess what I would say to the court is when an officer comes up behind us and there's 3 or 4 of us that pull over to the side of the road, as we are lawful to do, we have to do that. Are we simply detained at that point? There was more going on than just get back in the car. The situation was such that the officer was seeing unusual behavior at 1 o'clock in the morning with 3 individuals, at least 3 individuals,
Okay,
with no backup.
I'm sorry, let me interrupt because I'm getting more confused.
Okay.
All right.
And maybe I'm getting confused.
Well, was there ever a basis for claiming officer safety led the officer to do any of these things during this time period?
I think
in your view, is that a justification?
In my view, I think there was a number of things that were occurring, not only just officer safety, but also the safety of the individual as well as the defendant as well. The defendant, as I understand the facts, the officer, when the defendant got out of the car and approached the officer hadn't even gotten out of his car yet. So so at 1 o'clock in the morning, the defendant was walking out in the middle of the road trying to get back to the car to the police officer. The officer had at least 3 individuals stopped on the side of the road at 1 o'clock in the morning.
I understand that. So are you saying it was officer safety as a rationale for ordering the defendant back to his vehicle?
I believe that there was, yes, a degree of officer concern, an officer safety issue at that particular point in time.
Why isn't this case like other cases where an officer has a reason to make a stop and to detain this defendant? In this case, officer safety, the fact that he jumped out of his car and it was the right thing to do to say, get back in your car. So assuming that's detention, why isn't this case like any other case where an officer stops someone but then realizes that the basis for the stop has dissipated? They do have a temporary tag in their window that they didn't see at first. So they have a right to go up to the car and verify that, they're now free to go, to explain why they pulled them over, but not to ask for their ID and their license without some independent basis for reasonable suspicion.
Well, I don't think that the asking of the license and the registration occurred until after those indicators were present for the officer.
What indicators?
So, the bloodshot eyes and the slurred speech.
And is that confirmed by the record?
I believe it is, yes.
That he went, why did he approach the vehicle just to say then you're free to go?
And
I didn't mean to pull you over, you're free to go?
Yes.
Okay.
As a matter of fact, I think that the officer did testify that if it had not been for the defendant's actions prior to that, when he approached the vehicle, he would have told him you're released and not even have asked him for the license and the registration. So I think that with your question, it would have been the same if it had not been for the actions of the defendant.
Okay, so essentially you're saying that the actions of the defendant gave the reasonable suspicion of a new crime, basically, or another reason for continuing the stop.
Coupled with what the officer saw when he, in fact, did approach the vehicle to tell him he could go.
The problem is he needed the reasonable suspicion before that. It's a timing issue.
It is a timing issue. It's absolutely a timing issue.
So I think what my colleague's trying to pin you down on is when did he have reasonable suspicion? And And just a moment ago you said, well, it contributed, the behavior of getting out of the car and approaching the officer contributed to it, but then you said with what he learned when he walked up to the car. And we're saying if the detention happened when he told him to get back in the car, what did the officer have at that moment?
I have to tend to agree, and I do agree with the district court judge, that what the officer did in telling the individual to get back into the car was precautionary measures that a reasonable officer would take in that kind of situation. He had
if we agree with you, was it a detention? I think that's where you're bucking us here, is that you don't really buy that as a detention. So now I'm going to ask you to excuse me, counsel. I'm just going to ask you to assume that was a detention, just for purposes of argument.
Well, I think
then what was the reasonable suspicion at that point?
If you assume that was the reasonable suspicion, that was the detention. Okay, then you fall back and you have to analyze it from the perspective of the Court of Appeals, because that's what they did. They felt that it was a detention at that point. And then they developed this analogy of passengers and law enforcement safety. I understand how they developed the analogy of a passenger in that the defendant could not move. He couldn't get away like a passenger. He's stuck there. But then and I don't disagree with that if that's when the detention starts. And I think that if that's when you make a determination that the detention starts, then I think that the Court of Appeals is correct. That there was continuing to be an issue of officer safety. He couldn't just tell him, okay, go.
So the response to my question is he didn't have reasonable suspicion at that point. He just had a fear for his safety.
He had a fear for his safety at that time.
And following up on that, if you're done, Justice
Yes,
Breyer.
I am. Thank you.
the individual remained in his vehicle per the order of the officer to go back to your vehicle.
Yes.
And as far as the officer was concerned, when he went back up to the vehicle, his purpose was to say, you may now go. And as I understand your point, when he was about to advise the defendant of the fact that you may now go, they had this exchange of information, like, why did you stop me? And then there was the officer's observations of what he thought would be indicators of driving under the influence.
Correct.
And that then led the officer to ask for the license and registration.
Correct.
Is that right?
Yes.
So what, if I understand you correctly, this began as a detention of the defendant for the officer's safety,
Yes.
but then the officer felt that reasonable suspicion developed in his exchange with the defendant while the defendant was in his car. Is that what you're saying?
Correct.
All right. Thank you.
Correct.
If an officer has taken the action to ask him to step back in the car for officer safety, does he have a right to ask for the license without developing any other type of reasonable suspicion?
Well, in this case, I think an officer can stop him and ask him for, what are you doing? And the engagement in the discussion was, why did you get out of the car? I don't know. And then he saw that. But if it had not been for all of those indicators, I don't know that he would have been able to ask him for his license and registration if there was nothing more. If there was nothing more. But you can't ignore the fact that there was more. There was the other indicators that, in fact, he was under the influence. But if not for that, just if he had got back into the car and there was no other reason for the officer to make inquiry, or he had not observed anything awry, then I think he could have said, he would have been obligated to tell him, you can go ahead and go. Is there any more questions? Okay. Just as a conclusion, I do believe, and I would ask the court to affirm the district court's decision and find that there was not a detention at that particular point in time. However, in the alternative, I would ask the court to affirm the Court of Appeals decision if the court finds that the Court of Appeals decision with regard to the detention is appropriate at the time that they found it. But I would ask the court not to go as far as the defendant is asking you to go, and to create policies with regard and bright line rules, which is what I understand that he's asking this court to do, is to make determinations and bright line rules with regard to individuals, officers in that situation.
I thought we pretty much had some bright line rules.
I don't disagree.
And that the Court of Appeals opinion here basically went on a reasonable basis and didn't go on the bright line rules. And I mean, we start with the premise that all searches and seizures are unlawful unless they follow a warrant. That's pretty bright line.
I agree. I concede that there are areas and there are bright line rules in all areas of the law. But I think that when you make bright line rules in the area of search and seizure, in traffic stops, what you do is you hinder and you hamper law enforcement's ability to address issues as they evolve. Because every single traffic stop, every time an officer pulls an individual over on the side of the road, it's a different situation with its own unique set of facts that are continually evolving as that traffic stop starts and ends. And I think that bright line rules in this area would hamper the law enforcement's ability to address those issues as they're playing out. Thank you.
Any further questions of counsel? Thank you, counsel.
Thank you.
You reserve 3 minutes for rebuttal.
I just wanted to add one point in response to the Chief Justice's question that the call for backup was in response to Mr. Reiss getting out of his car. I think, though, that even if you have officer safety as a justification for this stop, you can still narrowly tailor the stop in a way that allows the officer to effectuate his purpose, which is getting the lead vehicle and investigating that. Remember that the officer in question did not approach the lead vehicle until backup arrived, and so he had somebody to keep an eye on Mr. Reiss to make sure that he stayed in his vehicle in compliance with the officer's orders.
And so you're okay with extending the length of your client's detention?
No,
You would be okay with extending the length of your client's detention for that backup period?
as a backup position, I would, Your Honor. I think ideally it would just be to throw the fish over the side of the boat. You don't get to keep it there until the end of the day. Tell him he's free to go.
Any more questions of counsel?
That would have nullified the officer safety problem too, wouldn't it?
I'm sorry?
That would have nullified the officer safety problem too, wouldn't it?
It
You just
would have,
said,
Your Honor.
Get out of here.
The Court of Appeals opinion speculates that you would have had somebody who was angry at being detained who would be cut loose, but I think that's pretty much the case in any time you have an officer-citizen encounter that turns out not to contain probable cause or reasonable suspicion.
Can we put that on the officer? I guess that's where I'm trying to get at. It's 1 o'clock in the morning, it's dark, there are 2 vehicles that got pulled over. Only one was intended to be pulled over, but your guy decided he had to. I understand that part. So now the officer's out there by himself. Your guy's out of the car coming to him. He has to ask for backup. He tells your guy to get back in the car. Now, do we put a fine enough line on that we say the officer had a burden to tell your guy get back in the car and leave, or is it fair for officer safety purposes to have called for backup, wait for the backup to get there, and to watch your guy while he goes up to the first vehicle? I'm not sure we can put the burden on the officer to make that fine of a decision out in the field like that. Does that make sense to? Are you really? I guess what I'm saying is, are you really saying that the only choice the officer had is to tell your guy to leave the scene?
I think you can tell him to leave the scene, or if that's not reasonable under the circumstances
for officer safety
purposes, then we can wait until backup arrives, keep an eye on him, make sure he stays in place. I kind of wonder, though, how often it would be unreasonable not to tell somebody you're free to go. I know that if I got pulled over by a police officer and he said you're free to go, I'm not going to really stick around him and ask him any questions. I'm going to get on my merry way. And I think that would be the response of most reasonable citizens, Your Honor. I think if you told somebody to leave and they defied the police order at that point, certainly something would be suspicious, and a much more vigorous investigation and detention would be in line.
And I guess what I'm asking is, I'm wanting to begin my analysis of your problem with this, with the officer walking up to the car after he has dealt with the first car, and then engaging your client, rather than anything that happened before. Because it seems like we have to give the officer all the breaks going prior to that because of officer safety concerns. I just don't think, do you agree with that, or do you think I'm cutting you too close?
I think that is. Frankly, there's...
It's okay, or cutting you too close?
Well, the one thing that made the officer concerned was that my client was walking towards him or charging him. The police officer describes it both ways, and he has his hands in the air and he's yelling or talking loudly. And he had stopped doing that. And there's no indication that he would have stayed at that point if ordered to leave. So I don't know that we have to cut the police officer those breaks all the time. I think we can simply say that he could have told him that he was free to go, and that would have been it. Even if we grant that that the prolonged detention could be there until backup arrives and you can investigate the first vehicle, even then the approach of him in his car as a further investigation, I think, goes beyond the purposes of that detention.
Well, you have the right to approach the person you've pulled over if the grounds for the detention have dissipated and tell them, I thought whatever I thought, and so you're free to go. And what I think the state is saying is, in the process of doing that, he then makes observations which enable him, which provide reasonable suspicion to extend the scope of the stop. And if those had not been simultaneous, you would have a different argument. But it sounds as though they were simultaneous.
Although the state is relying on facts that are not in the record. And in fact, the stopping officer specifically said, I was going to detain that guy and investigate him. He wasn't going up there to tell him he was free to leave.
All right.
If you look at page 29 of volume 4, he says, he hadn't even asked for the driver's license, registration, and insurance information before you, in your own words, ordered him back and detaining him further. Something further that was going to happen after backup got there, right? Correct. I think at that point, the officer had formed the intention that he was going to investigate this. He wasn't going to tell him he was free to leave. He was going to investigate him, Your Honor.
Okay.
Could I go back to the exchange you had with Justice Biles? And I want to make sure I understood one of your points, and it may be your second or third point. But one of the points you wanted to establish is that once backup arrived, there was no further concern for our police officers' personal safety, and your client should have been directed to leave the area. Is that right? Did I misunderstand?
Your Honor. I think that the officers had two options. One, he could have simply told the guy, leave right now, go, get in your car and go. If he waits for backup, I think that as a backup position from the free to leave, and maybe not even free to leave, but leave. I think is a backup position for that. If the court isn't willing to go that far, then you can at least have the second officer, the backup officer, keep an eye on the person, make sure that they stay in their vehicle while the officer goes and deals with the vehicle that was the subject of the stop. I don't think that they have to tell him at that point that he's free to leave. I mean, eventually I think they do, but...
So if you were attempting to correct opposing counsel on what the record indicated about the exchange or the purpose of the in-car exchange with your client, if that had not been correct, are you saying that had the officer here conducted his investigation for the subject of the original stop and then simply went back to your client and said, you may now leave, you'd have no problem with any of that? Is that right?
That's correct, Your Honor.
And that was in response to Justice Slukert's question about you don't have a concern about the length of the detention of your client.
I do, but I mean, I understand that it's a weighing test, and you have to balance the reasonableness and the length of the detention against the reasonableness of it and the purpose of it. I mean, ideally, I think that it wouldn't be, like I said, not free to leave, but leave. That sort of opposite of detention, get out of my face sort of thing. If the court feels that it's necessary to go down this line for officer safety, then we need to narrowly tailor these stops to effectuate their purpose while preserving as much of the Fourth Amendment as we can. And I think under those circumstances, then maybe a longer detention is justified, Your Honor.
There's also a safety element for your client, too. He's innocently caught up in a police situation. He gets out of the car. The officer doesn't know who's in the first car. And your guy's running around out there, so he gets ordered back in the car both for officer safety and for his own safety. Wouldn't you agree with that?
Well, I think then that the purpose of protecting Mr. Reiss's safety from whatever violence may befall him from the person in the lead vehicle, it sort of seems odd that you would keep him in the vicinity of this dangerous person. I do see that you want him off the road so he doesn't get hit by traffic. Is that your concern, Your Honor?
Or hurt by the people that are in the front of the,
Well,
I
think if that's the concern, then then the officer needs to order him out of the area.
That's a judgment call for the officer as to what what's out. That's my point. I mean, those are split-second decisions and how much lead time. But there is a safety issue for your client as well, and you would agree with that.
I would agree, Your Honor, yes.
Any further questions of counsel? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement. That concludes the docket. The court is now adjourned.